Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Bid to Dr. Suzy Fadilah binti Ismail, our class coordinator for the Law of Torts 1510 Section 3. My name is Mohamad Alif Helmy bin Mohamad Tarmizi, matric number 2015003. As for today, I would like to present my case review on the case of Entertainment Malaysia Sdn Bhd and Alif Iskandar Shah bin Muhammad Aminuddin and another appeal 2020 Malay Law Journal Unreported 1245. Without further ado, let me go through the summary of the case. For your information, the case has been tried in 3 different courts, which was the Session Court, the High Court, and later in the Court of Appeal. Okay. In instant case, it was the trial in the High Court. But before that, we would look to the summary of the case that had been tried in the Session Court. Alif Iskandar Shah, the plaintiff, brought the action to the Session Court against the Entertainment Malaysia Sdn Bhd, the defendant, in the claim of the loss of his belongings during his training session in the defendant premise. Plaintiff pleaded that the defendant had breached the duty of care in order to secure the safety of the customer's belongings in the premise. However, the defendant provided that the plaintiff had signed the membership agreement, and the agreement contained a disclaimer clause that can deny the defendant liabilities if any loss or damages occurred by the customers. The Session Court judge held that the plaintiff succeeded in proving his claims and allowed the claims based on the balance of probabilities. The defendant was liable to pay the plaintiff a special compensation of 4,668 ringgit, general compensation of 15,000 ringgit, and the cost of 5,000 ringgit. Unfortunately, the defendant dissatisfied with the decision made by the Session Court, and filed a notice of appeal to the High Court. Okay, we move on to the legal issues that been discussed. There are 2 legal issues being discussed here. Firstly, whether the negligence act of the defendant is proved by the plaintiff, and whether the disclaimer clause binds to the plaintiff. Next, we will look to the arguments by both parties. First of all, we look to the arguments by the defendant or the appellant. The defendant stated that by the virtue of the disclaimer clause number 3 in the agreement, that Celebrity Fitness, which is the defendant's premise, is not liable for any loss or stolen items on its premises. Next, the defendant also denied the presence of the plaintiff during the theft incident occurred. This is because the lack of evidence to show that the plaintiff was there during the theft incident occurred. Okay, we move on. Next, we will look to the plaintiff arguments. The plaintiff argued that the defendant premise has a weak security alert. This is because the premise has a weak attendance system. The plaintiff stated this statement because there was no record of the attendance of the customer and the members of the club. The plaintiff also denied that he was not there during the incident because the police report made by him is dated same as the incident date, which was the 22 November 2012. Because of his locker was breached, plaintiff stated that defendant was negligent in their duty to ensure the safety of the customers' belonging in the lockers. The defendant argued also that the defendant's staff convinced him that the customers do not need to worry about their belonging safety during the workout session. This statement made by the defendant's staff was the reason why he chose to register as a member of the fitness club. Okay, next, we will look to the decision of the court. Latifah binti Muhammad Taha, Haji Muhammad Taha, the judge of High Court decided that it was not necessary to overrule the decision of the Session Court. The High Court also retained the decision made by the judge of Session Court and dismissed the appeal made by the defendant, and the cost depends on fee allocator. Okay, we move on to the ratio decidendi or the basis of judgment. First of all, the court is in the opinion that the defendants must prove that the measures occurred is not caused by their negligence. Next, the court in the opinion that the defendant must prove they have taken sufficient action to avoid the theft. The court also stated that the application or the implementation of the disclaimer clause was unfair and just to protect the defendant from liabilities. There were also precedent used by the or referred by the judge of the session court to decide the case. Firstly, the Chin Hui 9 and Comprehensive Auto Restoration Service in Berhad and another. The judge before in deciding the case stated that the defendant have the burden to prove the innocence of their part, and the defendant have the duty to prove they have taken sufficient diligence and care to deny liabilities. Okay, the next referred case was the Premier Hotel Sendian Berhad and Tang Ling Seng. The judge of the case stated that the liabilities only can be avoided if the clause clearly stated the provision that exempt the defendant from any claim of negligence. Okay, for the last part of the case review, which is the analysis of the case, I divided the analysis into two parts, which are the significance of the case and the comparison with other cases. First of all, we will look to the significance of the case. The case of Alif and Entertainment Malaysia. The application of duty of care was implied in this case. As we all know, there are three main elements to establish a duty of care. First of all, the foreseeability of the damage. Next, the proximity, and is it fair and just and reasonable to impose the duty of care. In my opinion, there was a close proximity between the parties, i.e. the plaintiff and defendant, because the plaintiff had registered to be a member of the fitness club and had been given the registration number and the members card. Therefore, the defendant acknowledged plaintiff as one of their members, and this action would establish the duty of care of the defendant to the plaintiff. Next, the case also proved that the negligent act of the defendant. This is because the defendant failed to provide sufficient care to the plaintiff. This is because there was no workers or staff appointed to guard and to secure the safety of the locals, of the customers or the members. There are also no action taken to secure the safety of the customers' belongings. This is because everyone is free to enter and to exit the premises because there were no attendance taken by the workers of the premise. In this, those actions would like to increase the magnitude of risk for the incident, the theft incident or the theft case would happen. Next, we move on to the comparison with the cases. I used the precedent case used by the judge, which is the Chin Hui 9 and Comprehensive Auto Restoration Service in Berhad and another. This case also saw that the application of exemption clause to deny liabilities. However, the defendant in this case failed to adduced sufficient evidence that the damage of the plaintiff's car was not because of their negligence. Therefore, the court allows the appeal of the plaintiff. We compare to this instant case. The fitness club or the defendant failed to prove that they have taken sufficient action to secure the belongings of the customers. They only relied on the disclaimer clause number 3 to avoid liabilities. Okay. During the trial, the defendant's lawyer referred to the case of United Overseas Bank Malaysia, Berhad and Lee Yao Lin and another. However, the court rejected the referred case because in the preceding case, the exemption of liabilities was clearly stated in the disclaimer clause, including the negligence by the part of the defendant itself. And the disclaimer clause is effective to avoid defendant to deny the liabilities from the part of the defendant. To compare to instant case, the disclaimer clause number 3 only stated that the premise is not liable to any losses or damages occurred by the customers. There was no exact or clear terms of which and when the liabilities would be denied. I think that's all from my case review presentation. Thank you for lending me your ears, and I hope you have a nice day. Assalamualaikum warahmatullahi wabarakatuh.